Hi, Bob Murdoch here again. Today, we're going to talk about wills. Wills, as in your last will and testament, as in the way to plan your estate, the way to deal with what's going to happen to your stuff when you die. Everybody needs a will. You're crazy not to have a will. What if I told you that in terms of estate planning, a will is a terrible option? That the only thing worse than having a will to handle your estate is to have no estate plan whatsoever? What if I told you that there is nothing that a will can do for you in the way of estate planning that a better option will not accomplish faster, cheaper, more assuredly, and with more privacy than a will? Let's look at what an estate plan should do for you. First and foremost, and the most obvious, it should get your property distributed the way you want it. But really, there are a few other things you should be looking at. You want some privacy. You don't want to have to jump through a lot of hoops. You don't want things tied up for a long time. And you don't want it to cost a lot. So let's see how a will stacks up. First question, does it get your property, when you die, where you want it? Yes. Well, maybe. Sort of. The maybe's a bit bothersome. All states have laws that provide estate shares to spouses, children, or other dependents, and those laws trump what might be in your will. So we have a will. For the most part, it will divide your property per your wishes, but there's a big maybe. It's far from a clear yes. Whatever you put in a will may or may not be what eventually happens. So, question number one, does your property go where you want it? Yeah, that's the yes, but there's a big maybe. Okay, so we're not very excited about how the will did with respect to question number one. Let's move on. Let's talk about the second requirement, privacy. After all, this is your estate. It's your family. They're your friends. What you have, who you give it to, how you give it to them, shouldn't be anybody else's business, right? Wrong. With a will, you have to open a probate estate. The will has to be admitted to probate. What does that mean? That means you have to open a case with a probate court. It means you have to file the will. It means you have to have a personal representative appointed. More importantly, the whole thing is public. Anybody can walk into the courthouse at any time and open your estate file and see everything about your estate. What you had, how much it was worth, who you left it to. That's not privacy, boys and girls. On this count, the will fails miserably. Okay, we've got one maybe and one no. Let's move on. Simplicity. You don't want this to be a long, drawn-out process. You're trying to get your property distributed to the people you want it to quickly with no hassle. How does the will do on this count? Just as bad as with the privacy. It's a big resounding no. Here's why. As I said before, the will has to be probated. A probate estate has to be opened. That's the actual filing of a court case. That involves a petition for the appointment of a personal representative. It involves notices to potential creditors. You must file an inventory of the estate. Again, as we talked about with privacy, that's a listing of every piece of property, every bank account, every parcel of real estate, anything that you owned at the time of your death is published. You have to prepare deeds of distribution. Finally, you have to file a petition to close the estate. All of this requires time. All of this involves expense. So, does the will distribute your estate with simplicity? Absolutely not. So far, the will isn't scoring so well. But to be fair, let's take a look at the last two factors, time and cost. The time issue is effectively the deal breaker for using a will as an estate planning tool. Consider that all states have some form of required waiting period. after notice to creditors. The length of time varies. It can be a few months, it can be as much as a year. And this is not just a waiting period. During this time, nothing can be done with estate property. It can't be transferred, it can't be sold, it can't even be mortgaged to help pay expenses. It just sits there in limbo. On the question of whether or not a will gets things done quickly, it's not just a no, it's the proverbial train wreck. Finally, let's look at the cost issue. Start adding up what was spent, and we come up with a resounding no. So let's look at the scorecard. Of the 5 things we want an estate plan to do for us, a will gets 1 maybe and 4 no's. Not very impressive. I think you can draw your own conclusion on how well a will works or doesn't. Just having a will is not a good way to plan your estate. There are other, better, cheaper, and more efficient ways to get the job done. Be Your Own Lawyer can help you with these. Check out the link below to see how. Or contact any competent attorney. Just do something besides getting a will done that will turn your estate into the proverbial bucket of worms.